Okay. Hi, everyone. To start, this program is being recorded and the chats become public record as well. So welcome to the second in a series of programs on reopening businesses in our community. My name is Alita Camp and I'm chair of CB8. CB8, along with Carnegie Hill Neighbors, Community Board 6 and 5, the East 86th Street Association, the East Midtown Partnership, the East 60th Street Association, Neighborhood Association, and the Madison Avenue Business Improvement District have developed these programs to address the small business community's most important concerns about reopening, as reflected in the responses to the survey we sent to businesses. This evening, we're looking at the legal questions related to the employer-employee relationship in small businesses during this COVID-19 era. Please feel free to ask questions during the program by writing them into the Q&A box at the bottom of your screen. I can't promise that they will all be answered, but we'll do our best. Links to resources, guidance, and other materials referred to during this program will be listed in the chat. In addition to our featured speaker and moderator, you may see Matt Bauer, president of the Madison Avenue BID, and Rob Burns, president of the East Midtown Partnership, who may provide specific information. I'd now like to introduce our moderator, Jessica Walker, the president and CEO of the Manhattan Chamber of Commerce. Jessica, the Manhattan Chamber of Commerce is an organization that supports the borough's businesses. She has significant public policy expertise and has advocated tirelessly for New York's residents, neighborhoods, and businesses for more than 15 years. Among her many responsibilities, Jessica is a member of the Governor's Regional Economic Development Council and the Mayor's Small Business Sector Advisory Council, which will help restart the city's economy in the wake of COVID-19. Jessica, thank you so much for being here, and I'm going to turn it over to you. Thank you.
Thank you, and thanks for having me. I think the topic tonight is really, really important. You know, after the COVID crisis started, our chamber opened our help desk to businesses throughout the city in need, even if they weren't members of our chamber. And I have to say, you know, the biggest questions and concerns were around legal matters, because number one, there have been so many new laws and regulations passed, you know, in the span of 3 short months here to make sure that businesses were doing everything that they needed to do. But then also, you know, just because of where we are, there is a lot of concern about doing the wrong thing and maybe getting sued by, you know, a customer or an employee. So this is a really important topic. I'm glad that you guys have taken it up and also found a fantastic expert who can help us and walk us through this topic. So let me introduce our expert presenter tonight. His name is Michael Schmidt. He is the vice chair of Cozen O'Connor's National Labor and Employment Department and the office managing partner of the firm's New York Midtown office. In addition to his other litigation and counseling work on behalf of employers for the past 28 years, Mike regularly advises small and large employers on issues pertaining to the current COVID-19 pandemic, which is what we all need to you know, brush up on, including employer obligations and return to work questions. Mike also is the host and producer of his own podcast called Employment Law Now, which you can subscribe to for free on iTunes, Spotify, Google Play, and at www.employmentlawnow.com. Michael, welcome.
Thank you so much. Appreciate the opportunity to speak with everybody.
So we'd love you to just sort of walk us through some of the big major things that every business should be aware of as they're trying to reopen right now. And then of course, we're going to try to take as many questions from you know, the attendees that we can.
Sure. And again, I appreciate it. I was going to say what a great sounding introduction that was of me, and then I realized that I was the one who gave it to you. So,
but it's all true. It's all true.
Yeah, I'm just sitting here lamenting how many other great things I could have probably added to all of that, and you would have read it anyway. But thank you for that. In all seriousness, I hope everybody is doing well and staying safe and healthy. This is I think an understatement to say that it's been a crazy period of time. I keep talking to people about how normally in the course of a year, a 3-month period is such a small blip in the screen of our lives. You go from March to June, typically very quickly. And here we are in 2020, and this March to June seems like it's been about 5 years worth, some days even more. People are going through a lot from a financial standpoint, a health standpoint. just the physical, the mental toll that this has all taken on everybody. So I do hope everybody out there and your colleagues and your families are staying well. And hopefully in the time that we have tonight, I can offer some assistance and answer some questions that people have. I thought I would start off and take some time to go through some things on my mind about the legal aspects of certainly the COVID-19 pandemic, as well as some of the return to work issues from a labor and employment standpoint. Hopefully my remarks will answer a lot of people's questions, but certainly, as you just heard, after I'm done giving a little mini presentation, I'm happy to stick around and answer some more questions. So there are three buckets that I wanted to talk about tonight. The first bucket is going to be the 3 Ps. The second bucket is going to talk about specific federal and New York legislation relating specifically to the COVID-19 situation. And then the third bucket is going to be talking about a few return to work issues in particular, whether it's screening, temperature taking, and thoughts on employee accommodations. So let me start with bucket number 1, the 3 Ps. And what do I mean by the 3 Ps? I'm referring to planning, protocols, and psychology. The last one's a little tricky because psychology's got that sort of silent P, but it counts as a P anyway. And so what am I talking about when we're dealing with the 3 Ps? First, planning. Planning is so important. Many of you are already knee deep into planning for return to work. And planning is so important here. It's so important because things change almost on a daily basis. The regulations, the guidance, you're reading tweets, you're watching the news, you're reading in the paper. So many people have things to say, and everything that they're saying is seemingly changing on a daily basis. So the more you are able to plan, and for those of you who have been actively planning for some time, kudos to you, because planning is so important. But it is also important to remember from the planning standpoint that as comforting as it is sometimes to hear what other people in the neighborhood are doing or what other businesses in your industry are doing, ultimately you need to tailor your plans and your protocols and your activities to your particular workplace, to your particular workforce, the employees that you have, because at the end of the day, every business is different in a lot of respects. And the personality of the workplace and of the workforce is different from business to business, even those that exist on the same block. So it's great and comforting, as I said, to hear what other people are doing. You should be taking that in and listening. But at the end of the day, continue to take the time to plan what makes sense for your own business within the realms of what the legal requirements are. What kinds of things are people planning? When is the right time to open? It's one thing to be told by the city and state when you can open. When is it right for your business to actually reopen within those guidelines? Who should be returning to work, depending on the numbers of employees you have and what your situation is in terms of the physical presence? Who should you be returning to work if you're not returning everybody all at once, and in what phases? How are you going to continue to communicate with employees, both in terms of returning to work and while they do return to work? And how are you going to implement and enforce the kinds of policies that you've been planning to have, the kind of protocols that you've been planning to have in all of these days, weeks, and for the last few months? So planning, so important. The second one was protocols, making sure that you have protocols that meet the Department of Health, state and city guidelines for businesses that are reopening in the appropriate phase. What kind of protocols are you going to implement? What kind of protocols are you going to communicate to your employees when it comes to screening, temperature taking, the use of PPE, masks or otherwise, any physical modifications to the actual workplace, whether you're a restaurant, a retail store, or an office? What types of distancing and cleaning requirements and protocols are you going to have in place? And then lastly, how are you going to address the inevitable concerns and complaints that you will hear? Putting aside the reason that people will be making complaints, there's no question that employees will be returning to work quite often. And they will be looking around at what your best practices are and are not, and what kind of protocols you've been using in your particular workplace. So who you have designated to take in any of these complaints and concerns and how you will go about addressing them is an important thing to plan and to implement as a protocol. And then the third P is the psychology of all of this. You know, just because, and I talk about this with companies and clients all the time, just because you have a governor or a mayor or somebody saying you are allowed to open the doors doesn't mean that everybody is just going to be blinking and, you know, we're going to pretend that we're back into February and none of this has happened. There is a psychological impact. There is a psychological lag to all of this. Things may be different come next week. Things may be different the beginning of July. Things may be very different come the fall and maybe even into early 2021. But the important takeaway here is to recognize that your employees, your vendors, your customers, people are going to be reacting differently and will have a psychological lag to this return to work. So you don't want to have, as a business owner, as an employer, you don't want to have knee-jerk reactions to employee requests, knee-jerk reactions to things that employees are doing that maybe you don't agree with or maybe you don't like and might in another period of time discipline much more quickly. You want to address things, address concerns, address problems consistently, but you also want to have your mindset and your protocols have some degree of flexibility to them. Again, the psychology of the return to work is going to lag behind the legal permission and some of the other things that we're going to be talking about. When it comes to running your business and managing a workforce, be open to new ideas. Be open to approaches that people can suggest, that your employees can suggest about how to get work done while still maintaining a safe, a healthy, and an open door kind of environment. Again, at the end of the day, if you don't have employees who feel safe and feel healthy, that's going to hurt morale, and it's going to obviously hurt productivity. The old adage that a happy employee is a productive employee is an adage for a good reason. It still holds true. So those are the three P's in the first bucket that I wanted to go through. The second bucket I want to talk about is specific legislation that came about as it relates to COVID-19. And I do apologize if some of what I'm going to tell you is already known to you. But I think based on some of the discussions that I've had and some of the questions that I've seen, people are either unaware of all of this or people may be confused by some of this. So I wanted to take a few minutes and go through with you what this legislation, this COVID-19 specific legislation is all about. First, to get rid of this, I guess, misnomer that the legislation only applies during the quarantine period, everybody should understand that the new legislation that came out in March and became effective on April 1st is still in effect through the end of this year, through December 31st of 2020. It's always possible that Congress can extend the deadlines, but even if they don't, remember, as we're bringing employees back, that the legislation is still in place and these new obligations are still in place through the end of this year. So what are some of the, I guess, frequently asked questions that I get on this legislation? So when we're talking about the coronavirus legislation, I'm going to put aside New York State for a moment because it's much more limited. But on the federal level, we're talking about two new types of legislation. One is referred to as the paid sick leave, the federal paid sick leave. The second are the new amendments to the Fmla, the Family and Medical Leave Act. Importantly, this new legislation applies to all businesses under 500 employees, which I suspect is going to be everybody on this call. There is a very limited small business exception for those with under 50 employees, and I'm going to get to that in a moment. But for the most part, this federal legislation, the paid sick leave and the FMLA amendments will apply to all of you through the end of this year. What employees are protected by this and what triggers the need to give certain leave and certain benefits to employees? Let me respond to those questions. First, in terms of what employees are protected, because I get a lot of questions about, for example, my employee just started with me yesterday. is he or she entitled to these benefits because they haven't worked with me for a period of time. For paid sick leave, for the federal paid sick leave law, all full-time and part-time employees are entitled to the protections, regardless of how long they worked for you. For the second bucket, the FMLA amendments, an employee has to have worked for you at least 30 calendar days prior to the day that the leave request is being made. So what kind of situations trigger your obligations as a business owner to provide leave under these new COVID-19 buckets? Well, let's start with the paid sick leave. And under the paid sick leave, there are 5 reasons why someone is entitled to get leave. Number 1, that they are unable to work or telework because that individual is subject to a federal, state, or local quarantine order having to do with COVID-19. Reason number 2, the individual is unable to work or telework because he or she is advised by a healthcare provider to self-quarantine for COVID-19 reasons. Reason number 3, if the individual is unable to work or telework because he or she is experiencing symptoms of COVID-19 and is seeking a medical diagnosis. Reason number 4, and I'm going to get to in a minute why I'm being specific about numbering these reasons. You'll see why in a moment. So reason number 1, individual subject to federal, state, local quarantine. Reason number 2, advised by a healthcare provider to self-quarantine for COVID-19 reasons. Reason number 3, the individual is experiencing symptoms and is seeking a medical diagnosis. Reason number 4 is if the employee cannot work or telework because that individual is caring for somebody who is subject to a quarantine or an isolation order, or caring for someone who has been advised by a healthcare provider to self-quarantine. That's reason number 4. Then finally, reason number 5, if the individual is unable to work or telework because he or she is caring for a child whose school or place of care has been closed, or if the child care is unavailable for COVID-19 reasons. I want to highlight this last reason just very quickly because we're entering the summer months now and we're having that break between school closing, school being out, and camps, whether summer camps, sleepaway camps, other types of summer facilities. You may have employees who come and say, you know, I had these plans for my children, either through camp, through childcare, something that was arranged for the summer. And now because of COVID-19, that is unavailable. That is what would trigger this new COVID-19 paid sick leave reason number 5. A month ago, 2 months ago, for those people whose children's school closed because of COVID-19, that would have triggered this as well. But as we're getting to the end of June, to the extent that a school is closing because it normally would at the end of the school year and not because of COVID-19 reasons, that alone would not be a reason to trigger this leave entitlement. In other words, simply because someone's child's school is closing as it normally would at the end of the year, and it's not for a COVID-19 reason, that's not enough to trigger this paid sick leave reason. At this point, if you have an employee who's coming to you and saying that a camp or a child care place or some facility that you had arranged for summer care is now closed for COVID-19 reasons, that would trigger this number 5 reason. Without getting too much into the weeds, unless people want me to later on, certainly, or I can do it separately offline, the reason, the particular reason, the numbered reason that I've given you will determine what rate of pay the employee is entitled to. If it's a full-time employee, in other words, somebody who is regularly scheduled to work 40 hours a week, they're entitled to up to 80 hours of leave if one of these reasons exists. For a part-time worker, it gets a little bit more complicated. You have to start averaging the number of hours that they worked over a 2-week period to determine how many hours of leave they're entitled to for any of these 5 reasons. And as I said, depending on which reason you're talking about, will determine what rate of pay they're entitled to for those hours of leave. I told you a moment ago that there are two buckets of COVID-19 related legislation. The first, as I just went through, was the paid sick leave, and I gave you the 5 reasons that could be triggered. The other one I mentioned was the FMLA amendments, the Family Medical Leave Act. This is much easier because this mirrors reason number 5 under the paid sick leave law. In other words, you're entitled to additional leave as an employee under this FMLA bucket for that same reason number 5. If the employee's child school closes because of COVID-19, summer camp, place of care, daycare closes because of COVID-19, and that employee is unable to work or telework because of that. The leave under this bucket is a little bit longer. It could be up to 12 weeks. And there are payment requirements as well that the employee is entitled to for a portion of that 12-week period. So those are essentially the COVID-19 specific laws that were enacted and that will continue, as I said, through the end of the year. There are all kinds of, as you would imagine, legal terms of art in here, all kinds of other legal questions about how the leave is taken. Does it have to be taken all at once? Can it be taken intermittently? In other words, for a few hours in one day or for only a couple of days in a particular week? And again, I'm happy to get into some more of the weeds of that separately after these opening remarks or in a separate conversation offline. The main takeaway should be that a red flag should be brought here if you have an employee coming to you describing a situation that falls in one of the 5 reasons that I just listed for you. There are also notice obligations that employees have to provide to you in terms of what information, what documentation they are required to give to you if you ask for it once they describe a situation that's triggered by these paid sick leave reasons. The new laws also require that any individuals who previously had health care coverage, that health care coverage be maintained during the period of the leave. And they also have certain reinstatement rights after the end of their leave, either under the paid sick leave or under the FMLA amendments. So again, I just wanted to give you a high level kind of summary of the COVID-19 specific rules, and I'm happy to answer more specific questions after these remarks and even offline. A third bucket that I wanted to talk about in these opening remarks are just a couple of specific return to work issues relating to screening, temperature taking, and accommodations. Again, just to develop sort of the mindset that I think business owners and employers should have here. There is a lot of guidance out there. The New York State, from the governor's office, is one great source. The New York State Department of Health is another great source for COVID-19 related guidance. Again, it changes every day. They're giving guidance specific to particular industries, whether they're office-based, whether it's in retail, whether it's in construction. There's specific guidance, both required and best practice, that's worth looking up. But just to give a few general kinds of thoughts here. First, when it comes to medical screening, medical testing, you're hearing a lot about should we do temperature taking? What are other people doing? It's important to understand that having a fever does not necessarily mean that they have COVID-19. The flip side is also true. The fact that somebody may not have fever or may not have a symptom does not mean that they don't have COVID-19, the coronavirus. So for those who are engaging in temperature taking and screening, it's important to not have that as your end-all be-all way of addressing this. It's still important to still go through the social distancing, the cleaning, and some of these other best practices that people have been talking about. Just as a matter of yesterday, some breaking news, for lack of a better term, when it comes to testing. You are permitted to require testing for employees for the coronavirus itself, but you are not allowed to require that employees get tested for antibodies. The EEOC, our federal agency that deals with discrimination and harassment issues, just came out with that guidance yesterday, that we can require employees to be tested for the active coronavirus, but we are not allowed to require that employees submit to antibody testing. There are a lot of privacy rights that people ask about in this area when we're talking about medical screening, medical questionnaires. What happens when there's a positive test that we find out about? There is a difference between alerting government agencies when there is a positive case for coronavirus in your place of employment. There's a difference between that and disclosing identifying information to coworkers and other people at your company, at your store, at your location who don't need to know that information. Even when we're talking about terms like contact tracing as a means of preventing the spread, particularly when somebody does test positive for coronavirus, there is a protocol for doing it. There is a recommended way of doing it that does not include identifying individuals by name or other identifying features. So for those people who are asking about privacy rights and how does that play into all of this, there certainly is a balance. On the one hand, we need to establish protocols to avoid and prevent the spread of this disease, of this illness, while at the same time we do need to keep in mind the rights to privacy to those who have the medical condition or any medical condition, as well as with regard to any medical related records that people are maintaining. Accommodations is going to be a big one. You know, as I said before, the psychology of this is such that you will have employees who tell you that they can't return to work, they don't want to return to work. You're going to hear a lot about that this month, next month, and I suspect throughout, you know, the next several months. So it's going to be it's going to be the burden of really the business owner, the employers, to have to figure out how we're separating the types of accommodation requests we get. In other words, on this side, we have people who just have the same kind of generalized concerns, generalized anxiety about leaving their homes, maybe using mass transit, maybe going to work. Those are people who are just saying, I'm not willing to return. Maybe there's a group of people who are happy with, at least through the end of July, the unemployment insurance check that they're receiving from the government. And so they just don't want to go back to work and lose those payments. On the other hand, there are individuals, particularly those of a vulnerable, in a vulnerable group, who have an underlying medical condition. Could be physical, could be mental. And returning to work and exposing themselves to a particular work environment could exacerbate or likely exacerbate the particular medical condition. Unlike the folks that have sort of a generalized kind of concern or fear that is not supported by an existing medical condition, the people in that latter group may be entitled to accommodations by your company, whether that is to continue to telework, if that's something that's applicable to your business, or additional leave, paid or unpaid, depending on the type of position and the nature of the obligation. So it's difficult to impossible for me to come out and give you a list of all of the possible accommodation requests that you can get and all of the answers to all of those accommodation requests. I think the takeaway I want to leave with you on this issue is, as I said before, don't have knee-jerk reactions just because you have an initial threshold reaction to somebody making a request for an accommodation. It's important to analyze every situation on an individual by individual basis so that you can then properly determine, is this a situation that I need to accommodate? Or is this a situation where I don't have to accommodate and I can discipline somebody for not following the rules and protocols, or perhaps terminate them for refusing to come back in? You want to be consistent with your the protocols, but you want to be flexible, as I said, on an individualized basis. So those are some sort of general thoughts on the three buckets that I wanted to bring to your attention to just sort of set the scene and give you some context and hopefully set the mindset. I'm happy to answer some specific questions and get into the weeds on any of those buckets or any other related issues if people have questions in the time that we have left. I hope that was at least helpful.
Fantastic, Michael. I thought you did a really good job of laying out a lot of information in a way that someone like me can really understand. So thank you.
Thank you.
I just want to remind the attendees that there is a button towards the bottom of your screen that says Q&A. Feel free to type in any questions that you have and we'll try to get those answered for you. But I think I'm going to kick it off with a few questions and hopefully Alita can jump in as well. So first of all, my ears just really perked up when you talked about the paid sick leave, those 5 or 6 requirements or criteria for triggering it. And one of them was, the quarantine orders from the city or state. And so does that mean that pretty much any employee in New York is eligible because of the shutdown orders?
No, and there's been, and you actually hit a real important issue that we've been talking about for the past 3 months, frankly. There's been a lot of confusion over that. The Department of Labor has taken the position that no, simply because employees are forced to stay home by reason of the stay-at-home orders and these quarantines, that doesn't just entitle the general public to the up to 80 hours of paid leave. The Department of Labor, and I can tell you without getting too legal sounding, there is a lawsuit pending on this very issue where the Department of Labor is being challenged. But until that is resolved, where things stand now, to your question, the Department of Labor, the United States Department of Labor, takes the position that the individual, himself or herself, has to be subject to a federal, state, or local quarantine or isolation order due to that individual's condition. And that is the reason why the individual is unable to work or telework, not because of a general stay-at-home kind of order that applies to everybody else.
Got it. And then I think you're absolutely right. I've been hearing this a lot, that we are starting to see a lot of employees who are very concerned about getting on the subway right now. And I do think that this is going to become a real issue. So if you could drill down a little bit more there, I mean, I think clearly if an employee has, a health issue, that certainly is something that the employer wants to think about. But it's a little murky. Let's say the employee lives with somebody who has, is high risk, or also the other point is if the type of work that they do is such that they can't work from home. If you're running if you're like a sales clerk and you've got to do the cash register, so jobs like that where you really have to be there in person. Can you talk about those 2 scenarios a little bit?
Sure, absolutely. Great questions. And let me try to take them in the order that I'm remembering them. So in terms of somebody is living with somebody, that raises a couple of great points. And it's referred to as associational discrimination or associational accommodation, meaning that you are making a decision about an employee because of who he or she associates with. Maybe it's because someone that they're friends with, or in this case, somebody that they live with. From an accommodation standpoint, it's important to understand that while the laws currently as written prohibit you as a business owner from discriminating against somebody because of who they associate with, there is currently no obligation there to accommodate someone because of who they live with. So to be more specific, simply because you may live with a family member who has a medical condition does not mean that you as a business owner are required to accommodate the employee simply because that employee is living with someone who may have a health condition if the employee himself or herself does not. So there is not going to be an accommodation requirement under these laws in that kind of situation. But I do want to add, and a lot of it goes back to what I said before, both about the psychology and about the flexibility. And frankly, some businesses are better able to do what I'm about to say than others, simply because of the nature of the business, simply because of the size of the business. But I know a lot of companies are saying, look, I'll deal with the psychology by being a lot more flexible in my policies the first few weeks that we're returning to work. maybe things will be different. And maybe when we get to September, October, next January, I'll be able to take a harder line for people who don't have a legal entitlement to an accommodation. But for even now, the people who say, I'm just worried about going out, I live with someone of a certain age, or someone has a medical condition, even though you may not have a legal obligation to accommodate that, maybe you're going to be a little more flexible if you can. But again, there are businesses, particularly small businesses, that don't have the luxury to be able to just say, all right, well, 20 of you can stay home if you're still uncomfortable for no reason, because I only have a staff of 20 people or 22 people. So it is going to depend on the nature and the size of your business. But that's really why it's so important to analyze the situation when you do get a request for some type of accommodation, where somebody says, I'm not ready to come back to work, I'm not able to come back to work. You need to be able to figure out whether there's the legal obligation to accommodate that person because of an underlying condition, or if it's just a generalized concern. And for those people, the sort of generalized fears that are not supported by a medical condition or a legal need to accommodate them, it's really going to be a business decision for you. Are you willing to have more flexible policies for some period of time? Or if not, again, depending on your existing policies, at that point, you would be within your rights to say, if you're concerned and you don't want to come in, you get to use your PTO or whatever available time off that you have. And if you're still not willing to come in after that, and you don't have a basis to request a legal accommodation, they may be terminated.
That's really helpful. So we have a question. This is really interesting. This person runs a very small business. It sounds like she's the only full-time person, and she has 3 other employees who all work part-time, no more than 20 hours a week each. She's trying to find out what are her obligations to them. This is really interesting because in New York City, usually micro businesses like that who have 4 or fewer employees are exempt from some laws. And also, usually part-time workers are treated differently. So this is a great question.
It is a great question, and it's a problem. I remember one of the biggest questions I got back at the end of March and beginning of April when these new laws came about. People were saying, I don't understand why employers who have more than 500 employees are exempted from this. They're the ones who probably can best deal with the kind of leave and the paid sick leave that are under these laws. And without getting into really the politics of the answer, I believe that part of the reason for that is that when the government was when Congress was trying to get something on the books quickly to give relief quickly to employees, their thought was the large companies, those with over 500 employees, already have most likely paid sick leave, paid family leave on the books. So we don't need to provide this leave, because one of the things I didn't mention to you is that employers get reimbursed essentially dollar for dollar by the federal government when it comes to their quarterly taxes for every dollar of leave that they have to pay out here. So I think there was a feeling in Congress that, hey, for those who have over 500 employees, the real large corporations, they should be doing this already. We don't want to include them in here so that they're now also going to be getting a tax credit. The problem, or the potential problem, is particularly for those who are on this call, the real small businesses. There is a small business exemption for reason number 5 that I mentioned before, dealing with the individual who's unable to work or telework because of the school closing or the child care being unavailable. In those cases, if you have fewer than 50 employees, and if you can make a certain certification, document a certain certification that the viability of your business will be significantly threatened if you had to provide leave for just that reason, that number 5, then you're exempted out of that. But otherwise, there really is no exemption that's going to apply for these other federal reasons. So as I said before, unlike other statutes that you point out that have minimum thresholds, whether it's for employees or otherwise, for purposes of the paid sick leave, It applies to everybody, every business under 500, and it offers the benefits to employees, even if they're full-time or part-time.
Great, thank you. This is a good question here about, oh, Alita, do you want to jump in?
I had a question, and if I'm wrong and misunderstood you, Mike, please correct me. I believe you said that there's a reinstatement right under the FMLA, but my understanding is that after the leave from the quarantine, it's not really a leave, but the quarantine from COVID, that an employee's position could be changed. So after, what happens if they have some kind of leave under the FMLA, but you would have had the right to change their position had they not had that leave? Are you required to maintain them in the position that they would have had, even if you were going to change it as per your right, or are you able to change it, if I'm at all clear? And thank you, Jessica.
Yeah, no, you are clear. It's a good question. The requirement, the reinstatement requirement, after someone takes either the paid sick leave or the amended FMLA leave that they're entitled to, the right is to have them restored to the same or an equivalent position. Now that doesn't mean that if there was going to be a change in their position, irrespective of the leave and irrespective of the COVID-19 situation, if this was a normal business decision that would have happened otherwise, that's a different situation. But if the reason that they are out and the reason that you are either replacing them or filling that position is because of the leave that they are taking, then they do have a right under this law to be restored to the same or an equivalent position.
So then is my understanding correct that if you would have changed their position had they not taken the leave, you may still change it? But if the only reason for changing their position is because they took an additional amount of time for sick leave or other permitted leave, that you cannot then change their position just based on that leave?
Yeah, I think that's a fair statement. And I mean, it goes without saying, I think that there's obviously difficulty anytime you have a chronology that somebody's position has changed. And oh, by the way, they just either requested leave or they just came back from leave. The burden essentially is going to be on the business to show, as you just said, that they would have done that anyway for whatever decision making, whatever processes were already in place. You'll have to overcome the optics of the chronology that might not look good on the surface. But yeah, what you just said is fair.
Thank you. May I ask one more question, Jessica?
Please.
I thought we said one per person. I thought we said one question per person.
Right. This can go on
I didn't know
forever.
that you did the two I submitted. For bucket one, and because this is the first time that I've heard of something relating to employee complaints, you mentioned handling employee complaints, and I'm just wondering do you have any advice about what employers should do if employees are going to complain about something relating to the business, the number of hours, the number of customers, the way their temperature is taken, that you don't take temperatures of customers? And then would you suggest keeping records of those complaints and your responses for all of that? Thank you.
Thank you. They'll take the last part of that because I think that's the easier part. I would. If somebody's raising a concern to you, whether they've put it in writing or not, I do think it's a good idea. It doesn't require, a 10-page novel. It doesn't require really editorializing, but I think it's a good idea to have a contemporaneous record that somebody raised this concern, and very briefly, this is what we did to address it. And look, at the end of the day, not everything that somebody raises is going to be something that can be remedied or that you're required to remedy. But I think if you acknowledge, like I do, that you will have concerns being raised. Again, there'll be people who come back to work and, their entire 9 to 5 or their entire shift will be, for good reasons or for nefarious reasons, will be to look around and check out the conditions. And, my neighbor's place of work did this. I don't see you doing it. Look at, you're letting those 4 people talk within 2 feet of each other. There's so much information overload out there. People are going to come back to work and there will be concerns and complaints. So I think documenting that and your response is important. I think just listening and taking the complaints and the concerns in is equally important. because I find that while you are never going to eliminate all lawsuits, just given the nature of our judicial system, the nature of, our society now in 2020, you're never going to eliminate all lawsuits. But I do believe a lot of lawsuits, particularly employer-employee lawsuits, can be minimized or avoided just by better communication. And employees who think that their voices have been heard, generally and on particular issues, are the ones who are less likely to have morale problems. They tend to be less likely to go out and, spatter your name all over social media. They tend to be less likely to go out to the federal, state, and local agencies to complain about you. Again, I'm not saying that can always be avoided, but I am a big believer in better communication leads to employees feeling better about their employer. Even if something ultimately doesn't go the way they wanted it, better communication leads to better morale, which leads to better productivity, which leads to fewer lawsuits, in my experience.
That's great.
Thank you.
You're welcome.
That was a great question. Can we take that further? Let's say that you have an employee that does come to you and says, I believe that, I got the coronavirus and I believe that I got it through my place of work. So I think earlier in your presentation, you talked about the need to reach out to government officials, and certainly you had some recommendations around maintaining privacy. But what are some of the other things you need to do? I mean, obviously you want to protect your other employees, and of course you want to do the right things to make sure you're not going to get sued.
Yeah,
Right?
and a lot of absolutely. And by the way, a lot of this, and hopefully I'm not sounding like I'm answering a lot of these questions more generally than specifically. Part of the problem for a lot of these issues is it really does depend on the nature of the particular business that we're talking about. A lot of this is a lot different for someone who's got 60 employees than 9, or somebody who's got 20,000 square feet of a physical premise as opposed to 4,000 square feet. A lot of this makes a difference. But so to your point, if you find out that somebody has tested positive for COVID-19, in addition to telling the local Department of Health about that, there are 2 other things that you need to think about. Number one, if they are coming to you, as you suggested, and saying, I think that I got this from working at the office or at the store or wherever, it may be a workers' compensation issue. So that may be something where, a particular form needs to be filled out, and there may need to be notice given to, workers' comp through your broker or directly, because that would benefit certainly the business, and avoid, in most cases, not all, but most cases, a separate lawsuit. And that's the purpose of the workers' compensation system, to provide a system for employees who suffer injuries or illnesses arising out of work. And you'll let the system have that play out. Is this something that was provable that they got it from the office? I wouldn't play investigator, doctor, or police as a business owner. You're paying for workers' compensation insurance, I assume, for a reason. Let it play out through there. But the other thing to think about is if someone has a positive test, and again, the nature and the extent of this will depend on how many employees you have and what your space looks like. You may need to advise coworkers. Sometimes it's more obvious who that person is than in other situations, but you want to avoid giving out names and as much contact information as you can, other than to say, we've been informed that somebody who you may have been in contact with has tested positive for COVID-19. We want to let you know so that you can be conscious of any symptoms, or if you want to go and get yourself tested, we just want you to be aware of that fact.
Great. We have a question here, which is, I think everybody is very confused. The question is, what do I need to do to reopen in terms of filing paperwork with the state? I assume that I can't just reopen on my own. So I am very familiar with the safety plans that businesses have to put together, but is there anything else, Michael? And maybe you could just touch upon that quickly as well.
Yeah, no, that's pretty much it. And it's the Department of Health and the executive branch, the governor's office, has put together, as I said before, guidelines, both mandatory and suggested for different industries and depending on which phase we're in, but there is this safety plan template that the New York State has put out there and is requiring employees to complete and fill out. It's not something that has to be submitted necessarily, but it is something that has to be complied with and kept from a documentation standpoint in case there is an audit, in case the Department of Health or some other branch of government asks you about it. And frankly, even beyond that reason, it's a good thing to walk through because it talks about the kinds of things that I talked about. Who are you designating to get involved with the questionnaires and the screening? Who are you designating to address concerns? What is your plan for social distancing in your particular facility or work environment? So there isn't anything that you need to apply, in other words, to reopen. But that safety, the safety plan template that looks like it was just put out in the chat box is something that you should look through, ultimately sign and maintain as a document.
That's great. And here's another question, which is interesting. Can an employer take action against an employee who is known to not follow prescribed health rules out of work? This person is asking about maybe you see, risky behavior on their social media posts.
Yeah, that's a great question, and it's a tough question. And we've seen that specifically now with all the protests that we've seen, just by way of example. And I know companies have seen or heard that their employees are engaging in these protests, and maybe it's a problem of social distancing. Maybe they're engaging in the public protests without wearing masks. So you do need to be careful from a general, because this is a topic that I could talk about for hours, and that is, whether it's seeing something on social media or hearing about something that the business owner doesn't like, can we discipline them or terminate them because we don't like what they're doing or we don't like what they're saying or posting? And the same don't be knee-jerk in your reaction advice applies here as well. Just because you see something on social media, it was either a post or a picture or video, don't automatically assume, as I hear all the time, well, this employee is an at-will employee, I could just get rid of him or her because I don't like what they did. The law, and in many different kinds of laws, protects certain kinds of activities. By way of example, it protects employees who engage in what's referred to as protected concerted activity. If they are acting, two or more people, to talk about the terms and conditions of their workplace, hours, safety, wages, that's protected activity that they're entitled to engage in under certain situations that you can't just discipline them for engaging in that. Similarly, when it comes to protest activity, while there may be circumstances that allow you to say to people, we're going to require that you quarantine for 14 days because we know that you were out not complying with social distancing or mask requirements, and we now want you to quarantine yourself for a period of time, you do need to be careful about taking certain kinds of adverse action and people claiming that you're doing it because of the nature of the protest, because of what they're protesting, because of the nature of the activity, as opposed to it being because of the safety and health or the breach of protocol angle of it. So, takeaway, I can't give you every answer to every potential scenario, but the real takeaway for you is take a step back. If you were about to discipline or terminate somebody because of activity they're engaging in, and you need to analyze what the nature of the activity is, and is this something that I can take action because of?
Mm-hmm. I think this is going to have to be our last question tonight. This moves so quickly. Can you talk about wellness checks? What is allowed? Where does it get a little murky in terms of privacy issues? Or if an employee doesn't want to take part in those tests?
Yeah, so a great question to end with. One of the things you don't really want to do is here is the good news of there being so much information overload. And between the CDC.gov and the New York Forward link that was just put in the chat box, those two links, those two sources describe in detail the kinds of questions that you can ask in a medical questionnaire and that you can screen for. And the best advice that I can give you as a business owner is to not take it upon yourself to go beyond what they're saying you can ask for. So if, for example, we're talking about temperature taking, and so far, at least here in New York and from a federal standpoint, 100.4 degrees Fahrenheit has been the threshold for temperature taking, I would advise against taking it upon yourself and saying, well, I'm going to, have the threshold at 100.1 or 99.8. I think you are better off from a best practice standpoint being able to rely on and ultimately point to, if you have to, well, here's what the CDC told me, here's what New York Forward, here's what the New York State Department of Health told me that I can do. And so the point of that is when you're asking on a questionnaire about symptoms, when you're asking for activities that they've engaged in and who they've been around, I think you want to really mirror what New York Forward and what the CDC is telling you can ask and not really go astray from that.
Great. Michael, thank you so much. I think this has been so enlightening. I hope that it's giving the small businesses out there a little bit more confidence about opening up and knowing what they need to do and what they can do. So thank you so much.
No, you're very welcome. And the last shameless plug that I will give, and I appreciate you mentioning it at the beginning of this, is for those people who are not sick of hearing my voice, and I could see it looks like there's about 30 or maybe more people. If you're not sick of hearing me, I do have a podcast for those of you who like listening to podcasts. It's called Employment Law Now. You can find it wherever you find podcasts. It's also at employmentlawnow.com. I talk about all kinds of labor and employment issues, trends. I'll bring guests on. I've been speaking, as you would expect, over the past 3 months, a lot of episodes on COVID-19 and this whole pandemic. Just last night, which may be of interest to some of you, just last night, I interviewed the former chair of the New York Workers' Compensation Board. And we talked about, in this episode, the interplay between the workers' comp process and the pandemic and some of the questions that you were asking before about what happens if somebody gets this illness arising out of the workplace. So if you're interested in podcasts, and as I said, you're not sick of hearing me yet, feel free to download, feel free to subscribe. It is free. And otherwise, I'm happy to speak to you all again. I appreciate the opportunity tonight.
Thank you. Thank you. Thank you. I'm going to turn it back to
you. Thank you. Thank you. I'm sorry I jumped the gun there. And Mike, you made me think of a question about contact tracing, but we've run out of time. So thank you, Jessica and Mike. You've given us a lot of information for the businesses in our community during these terrible, unprecedented times. And thank you on behalf of all the business owners, managers, and employees. And for those, we want to see success, which is why we're doing this. You guys are the heartbeat of New York. Part 3 in the series is on community. Community can take part in the restart of New York. And so in 2 weeks, on July 2nd at 6:30, we're going to be talking with people about how the members of the community can support small businesses and do the right thing during these times. In the meantime, please check the CB8M website for other programs and committee meetings that you may find interesting. I thank everyone for staying, and again, and for all of the groups that we've worked with to put on these programs. And again, a very large thank you to Jessica and Mike. You've really brought a lot of information and a lot of, I write fact patterns for classes that I teach. So this stuff is really interesting and exciting to me. So thank you so much for everything and for being here and giving us your time and your expertise.
Thank you.
And
thank you as well.
On that note, we'll say good night.
Good night, everyone.
Thank you. Good night.
Thank you.